If you're getting divorced and have children, child custody is probably the biggest concern you have. In this episode, we'll discuss your rights so you can get what's best for your kids. Going through a divorce is tough enough. It's so much harder when you have children together. You want to take the high road and do what's best for your kids, but your spouse may be making things difficult. They may be making unreasonable demands or accusing you of being a bad parent. If you can't agree who gets custody of your children, you'll have to let a judge decide. Understanding what a judge looks for when making that decision is critical. You only get one chance. Let's make sure your kids are in the best possible situation. Categories of custody. There are two basic categories of custody: physical custody and legal custody. Physical custody addresses where your children stay. At whose house do they sleep? Who will put them to bed at night and be responsible for their daily needs? Legal custody determines who makes important decisions for them, such as medical choices, their religious upbringing, and education. Types of custody. Within the two categories of physical and legal custody, there are two types of custody: sole custody and joint custody. Sole physical custody is when your child lives with only one of you. Sole physical custody is rare. The court wants your child to have both parents in their lives unless it's not safe for them. In order to get sole physical custody, you have to show that the other parent is unfit. Usually, that happens when there is a history of physical abuse or significant substance abuse. Even in a sole custody situation, the other parent may be granted reasonable parenting time unless it's dangerous for your child. Sole legal custody is when only one parent is in charge of making those important decisions for your child. In a joint or shared custody situation, both parents participate more fully in raising your children. Before we discuss how a judge makes a custody decision, I just wanted to let you know that if you're considering a divorce in Massachusetts, we've put together a checklist and a free video mini course covering the 7 most important things you should be thinking about. Just visit affordlaw.org/checklist to get this important information. The best interest of your child. The court's main focus in custody decisions is what is in the best interest of your children. In doing so, the court wants to do what's best for your child's welfare, emotional health, and overall well-being. When making this decision, the judge will look to several factors, including your ability to meet your child's needs. Are you a capable parent? You'll want to show that you can take care of your kids if they're with you. You need to demonstrate that you can care for your child's physical, emotional, and psychological needs. Your willingness to support your child's relationship with your spouse. The judge wants to see if each parent encourages your child to have a relationship with the other parent. Don't speak negatively about your spouse to your kids. Encourage them to be in contact with their other parent. Make sure you're not interfering with the other parent's time with the child. Such behavior works against you and makes it less likely that you'll get custody. Your relationship with your children before divorce. The judge wants to see that you participated in raising your child on a daily basis. Did you spend time with your kids, put them to bed, get them to school, and so forth? If one parent has been the primary caregiver, that person is more likely to get custody. History of abuse or neglect. Obviously, any such history is a red flag for the judge. If your spouse is guilty of this, we need to make sure to let the judge know. If your spouse is accusing you of such behavior, we have to show that those allegations are untrue, or perhaps you've taken action to rectify the situation, such as getting counseling. Continuity and stability. Judges don't want to upset your children's lives any more than is necessary. Divorce is stressful enough for your kids. The court doesn't want to cause further trauma by making them move and disrupting their routine. Courts prefer to leave things as they are unless there's a good reason not to. Of course, there are situations where major changes have to be made. Such changes will be ordered if the judge thinks it's in your child's best interest. Child's preference. Sometimes a judge will want to hear from your child as to where they would like to live. These cases are the exception rather than the rule. The court is very cautious about asking this question. The reason is that they don't want to put your child in that very difficult situation. In essence, it's putting them in a position of choosing mom or dad. There is no specific age when your child can make this choice. It's a matter of maturity. The older the child, the more likely a judge will be to listen to them. Judges are also on the lookout to see if your kids have been coached by either you or your spouse when making that decision. If the judge does want to hear from your child, it's usually in the judge's chambers rather than having your child testify from the witness stand. Guardian Ad Litem. Sometimes a court will ask a third party to do an investigation to get more information. That person is called a Guardian Ad Litem, or GAL. It's usually a lawyer or a social worker. They will meet with you, your spouse, and your children. They will also meet with other people who are in your child's life, such as teachers, doctors, and family members. They will do home visits to your and your spouse's homes to see if they are safe and appropriate places for your child to live. The GAL will usually write a report for the judge to review. Although the judge is not required to accept what the GAL has presented, it usually carries a lot of weight. Parenting time. Parenting time or visitation must also be established. The non-custodial parent has a right to see their child unless the court finds them to be unfit. In that case, that parent may be denied any parenting time or ordered to have their visitation supervised. Otherwise, the court wants both parents to be actively involved in your child's life. Therefore, a parenting time schedule must be arranged. A common schedule is for the non-custodial parent to have the children every other weekend and one night during the week. But you and your spouse are free to work out different schedules if it suits you and is in your child's best interest. Child custody modification. Once the judge makes a custody decision, that order goes into place and must be followed. That order can be changed or modified in the future, however. Circumstances in the parents' lives change over time. People move, get new jobs, and have different demands on their time. As your child grows, their needs change as well. They become more independent. In order to modify a child custody order, you must first show that there has been a significant change in circumstances. Secondly, you have to prove that the change that you're asking for is in your child's best interest. For more information on divorce in Massachusetts, please see our next video.